Donna, you ready? You ready? Okay. Let me call this meeting together. Special meeting of the Board of Trustees for Laketran, May 18th, 2023. So in the absence of President Brian Falkowski, I will be taking charge of the meeting today and conducting it. It is a special meeting, so the agenda is very, very limited as to what we can talk about. And since there's only 4 of us, there's really no action that can be taken today anyway. So with that, Trudy, can you call the roll, please?
McTamey,
I'm here.
Sheets, Swanson, Zibble.
Here. If we can stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. I'll just read the mission statement here for us here real quick. Mission statement for Laketran is that Laketran is committed to providing quality public transportation services to all Lake County residents with special emphasis on meeting the transportation needs of seniors and people with disabilities. So I see no one in the audience. Have you received any?
We have not received any public comment requests.
Okay. So seeing or hearing of none, we will move on then to our discussion item, which is the Laketran rules and regulations. Purpose of this meeting was to get together again and go through some of the meeting or the reasons why proposed changes or suggested changes were being made to the rules and regulations for Laketran. Just to give you a quick update. Which one here?
Left, right.
Okay. Just last meeting that we had in April, we talked about with the history of the rules and regulations. And again, I just read through this real quick. They were adopted in 74. They were updated and adopted in 2001. In 2020, Brandon was asked to start working on those, and I offered to help in January. And then I spent a lot of time with Ben to talk about them in detail. In early 22, there was a meeting with Brian, Ben, and Brandon, and we just talked about the suggested changes at that time and kind of fell through the cracks at that point in time. And then in December, I think Lane brought something up again about the rules and regulations at the board meeting. So they were shared with the suggestions for changes were shared with the board members in an email in December. And then we had our special meeting on the 18th of April. Also stated at that time that Ohio Revised Code Section 306.34 and 306.35 give us the authority to create the rules and regulations for which we wish to manage and conduct our affairs. So that's the authority that we have to make sure that we can do these rules. So today, there was just really 3 topics that I wanted to make sure we tried to cover as best we could. And if there's time permits, we can talk about some of the other articles. And the 3 articles that I was talking about really here was Article 1 in the board, where we talk about appointments and removal of people from the board. Article 5, fiscal matters, deals a lot with where do we want to have a limitation on what can be purchased by Ben without authorization from the board. And then Brandon had proposed indemnification clauses also, and that would be a new Article 7. So again, trying today just to get a feel for whether or not we have a leaning one way or the other on any one of these specific matters. So just to go through again, the suggestions that were made were to really just remove some of the verbiage In section 2, it just removed some of the verbiage here relating back to when the board was originally organized and set some of the terms at that point in time. And the May 15th date of expiration of the terms now then would match what the commissioner's office has posted as the expiration date for the appointments for us here. In section 5, the suggestion there was that, again, if there's someone does resign or it leaves the board for any reason, that if it were to, county commissioners would be responsible for reappointing somebody, but if it were to remain unoccupied for at least 60 days, we would have the authority then to make a recommendation to the Board of Commissioners as to who they should reappoint. So, or should appoint to the board. Because by the Ohio Revised Code, the Board of County Commissioners can appoint and remove, and that's solely their power. The other part of it, sections 8 and 9, this is where I think we can get into some conversations on as to where the thought process on this one was, if somebody's not performing their job, they're not showing up, they're doing some unethical things or anything like that, what recourse do we as a board want to have to say, you're not really working in the best interest of Laketran, and we have some type of a process here to go through it to have that person removed, and it's a recommendation to the board, or a recommendation from the board then that would be taken by the president to the county commissioners and say, here's why we think this person should be removed. They can decide not to, or they can decide to move forward with it then. So I guess the big question for us to talk about here today, or to try to get some resolution for, is, do we really want to be able to do something like this? So I'll open it up to the floor to receive any kind of thoughts or comments back. Donna, you had indicated you had a comment.
I do. I came up with an example of exactly what we've been talking about. It's in GCRT's bylaws. And so I stopped and told Brandon, he was pulling it up. So if he found it, he could share that with us.
Yeah, Donna, I think that specifically speaks only to removal of officers. I don't see that it discusses board members specifically. When I talked to, I researched this somewhat extensively, and then I sought an opinion from the Attorney General, which I provided to everybody when I commented on that. And again, the only one that I've found, and I don't know, I think Ben's looked at a lot of these too, so maybe he's found something as well. It was Butler County. And the opinion from the Attorney General was more or less saying that Butler County is operating outside scope and power and authority to do that, which would then render its rules, void ab initio. But the language I've just found that you mentioned, I just pulled it up right now, as far as the Greater Cleveland RTA talks about Section 4, removal. All appointed officers shall serve at the pleasure of the board and shall be subject to removal by the board at any time. So the only section I found relevant is actually speaking as to officers, but not board members. I see Ben shaking his head. I assume you came to the same
Wasn't the
conclusion.
Butler County one, though? I mean, that to me was obvious. They were outside their bounds, because that was leading more toward, it sounded to me like a demand than a recommendation.
Yeah, I had a brief discussion with one of the assistant attorney generals who said, and again, what they tell you is they give you something and then they talk to you kind of off the record and say, but I didn't say this, so we're not telling you this. But it was interesting where he said something along the lines of, the idea is not to have it be a popularity contest for appointed boards, right? Where, not that Laketran would do that, but that a board is ganging up, it becomes a popularity contest and they decide, well, we don't like John Smith over there, so we don't think he's doing us right. Let's do that.
Well, what we were talking about was something that was, unethical, illegal.
Yeah. And I think to that extent, the board, you all can if you choose to put I think you could put a caveat in there, or I'm sorry, a sentence or a clause in there that says, in the event of that, I mean, we know that everyone that takes their oath, and we know that by statute, if that's the behavior, then you can automatically be removed, right? So the idea is, how does that become known to the commissioners? And,
That's the point.
and that would be something that, quite frankly, any board member would go to the commissioners on their own, or there could be language in there that you could simply state in the event that a board member. The problem is, what I've found in almost 30 years of doing this is you then are putting yourself in a position as a board where you're kind of the judge, the jury, the executioner, everything, making that decision and that recommendation. And the idea is that that power is not specifically given to the board by the revised code or otherwise. And some would say, framers of these things, kind of like you talk about the founding fathers, what was their intention? What's in there? What's not in there? Why? The idea is, to what extent is the Laketran board given that power and authority? And to what extent do they then, go beyond what they should do? So the idea is, how are they making that determination that, John Smith, we don't like what he did outside of here. He committed some fraud in some fashion. We're now going to go make that recommendation. Typically, the idea there is, if there's a criminal conviction, right? This old innocent until proven guilty, upon such time as that person would be convicted of that fraud or that malfeasance or whatever it might be, at that point in time, then they could be removed.
And that's a specific thing in the code for the reason for the commissioners to be able to dismiss a person.
That's
Malfeasance, misfeasance.
And non-feasance.
right. Yeah.
The original thought on why this was being suggested really was to, as Brandon had indicated there was nothing in here that said any one of the 9 members of the board could go to the commissioners and say, I don't like what Mr. Smith is doing, and he should be removed. And that would be the only voice. And this one I thought was pretty strict in the fact that there would only be one dissenting vote allowed to not go forward with the resolution to the commissioners. And that would be absent of the person that's being asked to be removed. So if I was being asked to remove, my vote wouldn't be counted. And then if Gary, you said no to, or you and Lane said no to it, then that would be the end of it, and nothing that would be taken to the commissioners at that point. That was the intent.
I'm a little uncomfortable with that whole process. It seems to me that we each have a voice, and if we're uncomfortable, we have the opportunity to speak to the commissioners independently, if that's what we chose to do. I think, in the interest of collegiality and harmony, to whatever extent you can find harmony when somebody's a bad actor, I think punting it over the fence to the commissioners is exactly the right step. And I would not be in favor of these things get amazingly sticky, and you can't be half pregnant on it. It's either there's either a full doctrine that says the following steps will be taken, and the whole process has to be documented out, or not at all. But a half measure, I think, leaves us open for all kinds of suits and countersuits and ugliness. So in my own view, the simplest answer to this would be to say, we each have a voice, and that's, that can go to the county commissioners and say, I think this guy's acting badly. You guys need to take a look at it, because you're the hiring, firing guys. So that's probably an oversimplistic view of it, Chuck, but that would be my view of it. Is it's a having just said it's sticky, now I'm going to say it's a slippery slope. But you know what I'm saying? It's complicated, right?
Yes.
And the moment we open the door for some sort of rule and regulation, I think it becomes an onerous rule and regulation, which would be unnecessary in my view, because we can't really do anything about it anyway.
Mhm.
I mean, we can say we've got a unified voice and we want this bad actor off the board, but we still have to go to the commissioners and they still have to decide it.
Right.
So,
If one individual, part of the reason for wanting to put something like this, if one individual did want to go to the commissioners and plead some type of a case, and if the commissioners chose not to really investigate it a lot, then where would that take us then to?
That's my question.
but we would have the same problem.
But so maybe we could still handle some of it internally to our own board. If we bring it up to the board and to the person, and maybe it'll correct itself before it would have to even get to the commissioners.
I think, if I may, I think what's telling and notable here is that, and I respect everybody's opinions on this, there is not one transit agency out there I found that has any language allowing that. And the Attorney General, in their opinion, and the code doesn't speak to that or allow that. So my fear is legal counsel, right? If I'm suggesting to the board, yes, I'll draft these things for you, are we now going down a path that it's not malpractice, but am I not giving you proper legal counsel because it's not necessarily given? So I would use the example, maybe like indemnification. The revised code doesn't allow Laketran to indemnify, right? We're not able to do that because it's not specifically a power given to us. Without that power given to us, we can't do it. So in every contract I go through, and Ben knows this, people put language in there. I mean, I can't remember the company in California. We went round and round, and Andre and I were ready to lose our minds. They wanted us to indemnify them on things. And I said, I'm sorry, we can't. And I finally had to say to them, look, you can look at our statute. We don't have the power or ability to do that. Absent that power being granted to us, we can't, whether it's, specifically enumerated or not. So my fear here is in researching this, looking at it, and then getting an opinion from the Attorney General, which kind of says, hey, what Butler County is doing is wrong. They shouldn't do that and can't do that. And they're essentially violating the code. That's just my concern. So, the board can, at its pleasure, whatever you want to do, and I'll do it. I just want to give you that caveat from a legal perspective. I would be uncomfortable doing that because, and then in part two, to what extent, how do we define that? Where does it stop? Where does it go? And then who are the folks? Just my 2 cents.
It strikes me as something that would be incredibly difficult to get on a piece of paper without it growing into, a multi-armed, octopus kind of a thing. And the truth is, at least in my view, that's what the president and the vice president of the board get their extra pay for. Is, hey, if we've got a bad actor,
Whatever.
Oh, I'm sorry, I let it slip. You weren't supposed to know about that, Donna.
Does that mean I get back pay?
Yeah, right.
Okay, you heard him.
With treble damages.
Bylaws.
That's the thing, real quick to interrupt. Maybe everybody should be concerned with that because there is provisions by which you could be paid for what you do if the commissioners decided to allow it. So maybe that's the action that everybody should be taking to the commissioners.
So, but that's my view of it is
Sure.
if we have a bad actor, we do an in-house sort of attempt to police a little bit, which really comes from, the president and the vice president of the board. It seems to me having a sort of a Dutch uncle talk. And if that doesn't resolve the issue, or if we truly do have a bad actor, then that gets sent over to the commissioners to act upon it. But we'd be a toothless tiger. And I guess that's my fear.
May I interject something?
If we have a handheld vote, I don't like Bill, he's a bad actor, he's got to go kind of a thing. And the commissioners say, well, no, he's going to stay on the board. That really begins to hurt our, we've become fairly dysfunctional at that point. And we've all read about these, like the Willoughby Hills fiasco that evidently continues to this day where they're willing to shoot each other. Well, that's an exaggeration, but you know what I'm talking about.
Yeah. Gotcha.
I'd hate to see us slide into that kind of thing because we've got ourselves trapped into some sort of a
Mhm.
procedure.
Okay.
Sorry.
If I may interject something here, what this says to me, because frankly, we ended up in what you just described without any mechanism to deal with it. So trust me, even without anything in writing, you can end up like Willoughby Hills.
Oh, I'm sure you can.
So in essence, we're saying, oh, well, we can't do anything. We just have to take it and try to work our way out of it next time it happens.
But at the end of the day, the only ones who can do anything about it, Donna, are the commissioners.
I get that, but that,
And so my argument would be hand it off. You know, hand it
Well-
off.
And that was, and I get that part of it here. The only thing is how do we as a board want to go about doing that? Just not showing anything in here and saying, these are some of the guidelines that if you're not here for 4 consecutive meetings, you know, you're going to be asked why you're not here. And are those reasons then to not be on the board? And if they refuse to resign, then what recourse do we have? We sit here with just one open seat for a long time, possibly. And that was the only reason of trying to define some things
Yeah.
like that.
No, I understand it 100%. I just, my view is it gets so sticky so quickly.
And see, I would have argument back the other way too, saying not having something, we could get into some discussions that way too.
Right.
And I'm personally, I'm fine either way. I put this in here, made this suggestion just based upon, hey, what happens if somebody just doesn't show up for a lot of these meetings? I mean, we need to have the people here
Right. Right.
to help us manage and go through the processes.
I agree. In my view, that's a bad actor. You know, if somebody comes onto the board, and I think every volunteer board in the world deals with somebody who just wants to be on the board and be able to put that on their resume or whatever, but doesn't really want to participate. I've witnessed that on a couple of different boards. And so I understand the reason why you would want to have some mechanism.
and in nonprofits, they usually do. To address like absenteeism and so
Well,
on.
I would think nonprofits will have much more control over their board appointments themselves than what we would. All the ones nonprofits I've been ever involved in, they come and say, would you like to be on our board? I say yes, and then they put you on the board. So they don't have that extra level of politics with the commissioners.
Well, so
Understand that.
So Chuck, your suggestion here, if I have the right version, I may have fallen behind. What you're really saying, you're talking about the 4 unexcused absences as a sort of a triggering event, right?
Right.
And then there's an excused absence, okay. And that, is that the extent of where you want to go with this? Is that the extent of your?
Well, that was,
Because we can't do the other steps if I understand our legality structure properly.
well, if someone is acting with malfeasance, and we wanted to take that as our argument back to the board or the commissioners and say, Mr. X is doing some things malfeasantly, then we need to have him removed. I mean, that would be a case then for the commissioners to say, okay, what is your evidence of why he's doing, what's he doing and things like that. So there is some things there that we have to have done. But if Brian or the president, I should say president, or if anyone else on the board were to just to be able to go and say, Mr. Commissioner, this person's acting this way, I think he should be removed, and this is a couple of reasons why, and the commissioners don't investigate it any further, then we get shocked as a board. A little bit too, because now the commissioners have unappointed a person, and the rest of us are sitting there going, what happened? And that was part of the only reason why I had some suggestions in here about trying to say just 2 dissenting votes would kill it.
That exists today, right? But there would be nothing in the change that would stop that from happening either going forward.
The way the rules are today, anybody can go to the commissioners.
But there's nothing prohibiting me from talking to the commissioners anyway. No matter what rules you put here,
Right.
I have the right to go talk to the commissioners, right?
I agree.
Am I missing something?
No, it's just in the hope would be is if you follow the rules and regulations because you're appointed to the board here and it says we have to have a resolution passed by the board before we can go to the commissioners and talk about Mr. X not meeting his obligations to the board. We're all voting on that, knowing that that's what's going to be happening, rather than us being a surprise.
Okay, I guess I missed that part of it.
That's why that was the rationale why this suggestion was made.
And keep in mind, if you do that, you're doing that in a public meeting as well, right? So it's not something, so just keep in mind that that's going to be a topic that would be part of any public board meeting.
That wouldn't be an executive session?
No, it doesn't. There's no prescribed part of 122.12 that allows that.
Okay, thank you.
And probably from that standpoint, I mean, it would have to be pretty blatant before we would even want to do something like that, I think.
Yeah, and I think the fear or the idea then is to what extent is this board now becoming quasi judicial within itself and making judicial determinations, perhaps taking on evidence, allowing that person to defend themselves or act, because now it's in a public meeting, they may very well be aware of it. Are they then entitled to counsel? Does that attach to them? And then is there a hearing? And to what extent does this board, the board doesn't have the power to do that, right? Commissioners appoint the board to be board members to guide Laketran, not to serve within itself as a quasi judicial board.
And that's the kind of mess that I'm afraid the rules would lead us into. There's no saying that the absence of rules won't lead us into the same position. Here's a hypothetical for you. We get into a discussion about a bad actor on the board and somebody makes some sort of a scalding remark. Now, are we talking about, what's the right term? Assassination or something?
Defamation.
Defamation.
Slander, libel. Yeah, that was going to be my next thought, because now that particular board member, in the event that there is no truth to the veracity of the allegations or otherwise, you meet this criteria for defamation. There's about 7 particular things there. Is there truth to the statement? Was it communicated to a third party, or was it false? You go down the test, and now you have exposed yourself potentially personally to a defamation action and or the board itself. So just another concern there, because now you're acting in that capacity, talking about somebody else, and to the extent that you maybe believe the evidence to be what it purports to be, but if it's not, then you've got to be careful. And then you're, of course, allegedly acting outside the course and scope of your position as a board member. And so Laketran then, we get an indemnification. Does Laketran then have a duty to defend you? And Laketran would say, well, no, we don't, because now you're not acting in the role of which you've been appointed. So it leads you down that as well.
If it's not in the rules or regulations, or you can get there either way.
I think you can get there either way. Yeah, I think, but now if you're codifying some of that and you're putting yourself as a board in that position where you're going to be having these discussions, again, you put yourself, you open up those potential things, but you could open up yourself to that anyway. Nothing right now prevents the board necessarily from within a public meeting. And I guess my thought is it doesn't have to be in your rules and regulations. So if you were having a meeting this coming Monday and you had somebody who was was absent for meetings, and you said, geez, we haven't seen John Smith, and nothing prevents Brian from going on the record and saying, we haven't seen John Smith in about 4 meetings or so. Not sure what is going on with him, if he's still an active, viable member of the board. Brian may say kind of on his own, sua sponte, well, I'll talk to the commissioners about it and advise them and let them know. Same thing could be if, whatever the discussion is, if we think you have to be careful how you phrase it. If you thought there was some malfeasance or some illegal act, you would say, well, I have some concerns about Mr. Smith, and I will, on behalf of the board, talk to the commissioners and report back, whatever, right? There's so many, hypotheticals and contingencies within what we're talking about that it's hard to kind of define and quantify.
It all comes down to, Brandon, we're darned if we do and we're darned if we don't. It all comes down to we're darned if we do and we're darned if we don't. Therefore, we probably do nothing.
I didn't
Say
hear
that
you.
last part again, Don.
Yeah, I'm sorry, I didn't hear you.
We're darned if we do and we're darned if we don't. So it's likely to come down to we just do nothing and move on to the next issue on Chuck's page.
Valuable input. Lane, would you have any thoughts or comments that you would like to make on it?
My
Okay.
God, this. It's not that hard. If somebody was on the board that was doing something totally illegal and everything, just common sense to get rid of the person. My God, I've been on boards. Some of them say if you miss 3 meetings, you're out. I mean, there are rules and regs and laws and things you can put in there, but what we're talking about is a bunch of hypothetical stuff that's probably never going to happen. We took an oath when we became a member, not to try and use Laketran as for business purposes or whatever. If somebody violated that, they'd immediately be out because that's against the oath they took to be on here.
But
It's
there-
so simple and so straightforward. Why are we wasting our time talking about things that might never, that probably, no, won't ever happen? If somebody was really that bad of an actor, we'd get rid of him one way or another, or her or whoever. You know that, and so do I. So why are we wasting? We just can't put some simple wording in there that says, if you violate, the laws of the state of Ohio or whatever, you're out. I mean,
We
that's,
don't have that authority, Lane. We do not have that authority. You can make that claim, you can.
okay.
you can
Well,
say
let's,
that,
okay,
but
let's,
Only the commissioners have that authority.
well, then, if that happens, then we turn it over to the commissioners and let them make that judgment.
But that's precisely what this discussion is about. Is that a formal process or is that an individual process? I mean, that's exactly, I think that's the root of what we're talking about here.
I would agree. I would agree.
Well, then make a sentence or a paragraph that says that, and let's move on. I mean, this is not,
Correct me. I'm sorry. Sorry.
that's,
I vaguely recall that there's something in the Ohio Revised Code that basically says that there are ethical things that we need to follow and be as a board member. And if we don't follow them, actually, I think it's in that 306-34. So it's in the Ohio Revised Code. And so that would be part of the reason then to go back and say, you're not following the Ohio Revised Code if you're violating these things.
Yeah, I'm pulling up the code right now to
Yeah, I
find a
understand.
specific section.
I can't, I don't remember myself where that actually is at, but. Yeah, so. Forgive me for not having that directly here available for us. There's just something in the code. Did you find it?
I can, 306.34, if you'd like, I can read it. It's fairly short. All the power and authority granted to a regional transit authority shall be vested in and exercised by its board of trustees, which shall manage and conduct its affairs. The board shall, within the limitations of sections 306.30 to 306.47, inclusive of the revised code by its rules and regulations, provide the procedure for its actions, the manner of selection of its president, vice president, secretary, treasurer, and other officers, employees, their titles, terms of office, compensation, duties, number, and qualifications, and any other lawful subject necessary to the operation of the regional transit authority and exercise of the powers granted to it. So that gives the board the power to do these things. Again, the question comes down to, and what the Attorney General opinion is, what everybody else has indicated and what the other transit authority rules and regulations are those provided. It's not specifically giving the board power to essentially manage, adjudicate, or handle its own board members as far as removal or suggestion for removal or appointment or otherwise.
Well, so Chuck, let me make just a quick, go ahead.
I'm sorry. Brandon, 306-35, D4, section D4.
Do you want me to put this on the screen?
If you can get it quickly.
What section did you say it was?
306.35, he said.
Yeah, D4. And what I'm reading here is no person shall violate any bylaw or rule of a regional transit authority adopted under Division 2 D2 of this section. And there was a few things in here above and beyond what was in 34. It doesn't really talk about the effectiveness of the board member. I'm sorry, Gary.
No, that's fine. What about putting something, rather than getting caught up in what I think can become an endless list of trying to capture all the various aspects of this? What if we put some sort of a comment in, a little bit like what Lane is saying? Some sort of comment that basically says, give me a lot of latitude on the words. I'm just going to make this up real quickly. But in the case of a bad actor, the board president and vice president will take, appropriate steps or some such thing that appropriate steps to bring that to the commissioner's attention or something.
Yeah.
Which doesn't have any teeth in it, but basically says, look, if you're a bad actor, it's going to be reported to people who can terminate you. Because I'm just afraid we're going to get on a slippery slope and we're going to end up with something like this, a list that's a mile long.
Well, that's, in my view, not a bad idea, because at least by way of our bylaws, we're formally empowering, if you will, or instructing the president and vice president, if there's a problem, this is what you need to do. Take it to the commissioners. And if there's even a tiny amount of teeth in it, would that help prod the commissioners to address what we're telling them?
Who knows?
I think the issue that I think the board needs to really consider is how it's defining the bad actor. And where does that take you in that definition? And what do you potentially open yourselves up to?
Yeah.
And I just think you have to be very, very careful with that, because you see that oftentimes with people. And again, that bad actor, if you're talking about a felony, okay, is it a felony involving fraud, deceit, or dishonesty? And we look at those characters, those are things that we look at in the law frequently as to removal or a particular crime by which someone then can't serve in some official capacity. For instance, I serve on the Board of Commissioners of Character and Fitness of the Supreme Court, and we identify and evaluate who can and can't take the bar exam based upon what they have done or not disclosed. We have a very limited number of rules, but it kind of can expand for us for obvious reasons, right? But we have to be very careful here if we're going to go down that path. And then what role is Laketran's board really in defining those things? Is that as part of the management of the Laketran Transit Agency, or are we now concentrating on things that maybe put us in that quasi judicial position again? And I just would caution you all very carefully of that.
It's rooted in the ORC that only a commissioner can remove someone, but it's for misfeasance, malfeasance, or nonfeasance. Do I have that correct?
Well, I didn't study, I think the commissioners have some broad latitude to what they can and can't do with removal. I didn't look at particularly what they can do or if it's codified for them or not. And I think, it talks about that, it alludes to that in the transit statutes that I provided, but, to be quite honest, the three commissioners could decide for whatever reason they wanted and not have to provide that. For instance, when we're picking a jury, we have what's called challenges for cause or peremptory challenges. I can make a peremptory challenge that I don't like John Smith on my jury, and I don't have to tell the judge or anybody why. I suspect the commissioners could do the same thing and decide they want to remove someone or appoint somebody new and kind of do that at their pleasure. That's their, that's the luck of the draw being a commissioner, I suppose.
Can I suggest that we sort of table this part of the discussion for a little bit and see what the other parts of our discussion look like?
Okay, that's fine. Brandon, I just say that the sentence here is really, I think, is the only thing the commissioners have authority to removal of it, and it's for those three items that. Yeah, but they could probably. The question would be: is what is malfeasance, misfeasance?
Right. Exactly. How does that define?
How do you define all that? And so,
Find it out, please.
yeah,
What section were you looking at?
306.33, second paragraph. And Gary, I'm glad to table this. I'll just make my final comment then as we table this, is that after this discussion and with Brandon's input on all this, I can see where this could end up being more issues than there is value to it. So you probably shouldn't even address it at all. if there is that issue that comes up at some point in time in the future, we just have to deal with it then and probably have to figure out what we want to do as a board at that point.
Yeah. Yeah. And just one quick final comment, having served on a couple of other nonprofit boards, this kind of an event always ran to the president and the vice president of the boards, board behavior and board discipline.
Yeah.
Ended up with the president and the vice president.
And again, Gary, the only reason I was thinking of something like this was because of any concern that I know all of us have relationships with the commissioners of some sort, that we couldn't go in there and surprise the rest of the board.
Oh, no,
That was the only reason.
I 100% agree with your concern on that. But I don't know how we would stop it anyway. That, at the end of the day,
Yeah.
I don't know how we would stop that.
Okay.
But I agree with your concern.
Okay. All right, we'll just move on here then. Yeah, so just, okay. All right, moving on then to the next one, which was second, Article 5. In here, they had a lot of comments regarding the president having to sign things. And it's not really how we're working at this point in time. CEO is based. One of the things that we need to talk about changing too, is the general manager to CEO. If there's any concerns with making that kind of a change. But if we go, the CEO has a lot of authority to make a lot of these purchases and the signatures on it. And correct me, it requires 2 signatures, yours and Lisa's, on checks, or is it just one signature?
Any purchase order requires 2 signatures, which is me and Lisa, and any check requires 2 signatures, which is me and Lisa.
Okay, so we have some checks and balances there. So part of the question there is, how much control do we as a board want to place upon the purchasing authority for Ben in its organization?
And the proposal would be to move it to 100,000. Is that right?
The Ohio Revised Code would say
Oh,
you're
I see,
allowed to
yeah.
go to 100,000.
I got you.
All
Okay.
right, we can set it at anything we want. We could set it at 10,000 or 999. 9,000, 99,900. So, the only part of it there was, we could put it at 100,000. That would be up and running with the Ohio Revised Code. We could put language in there maybe where it would run consecutive or run concurrently with whatever the Ohio Revised Code says. So if the Ohio Revised Code increases to 125,000 in 5 years, would automatically follow here too, for us to have everything 125,000 and under.
It's change it.
Well, there's a lot of language in here that talks about different things of board having to sign off on things, and that's not happening at this point. So we're just trying to update.
It's not happening.
Well,
I don't recall anything in the last 6 years I've been here that this $25,000 expenditure was causing undue delays or costs or whatever. It seems to me that it's a pretty good number. Ben, do you have a problem with that?
If I may interject something here, there's.
Ben, excuse me. I asked Ben a question.
I get very nervous answering questions about this since it's the board's opinion about.
6 years, well, with not meeting this $25,000 number to have board approval.
I mean, I don't know if was there a problem? I mean, I I can't think of a time I would say there was a problem.
I think there's a problem going forward.
I think that it's a state of mind for us. So we just know when we think about things, what number the limit is. And so I don't think I would say there's been a problem. Part of me, I appreciate the question, Lane. I feel uncomfortable answering it to some extent because it's more about what you want to see as a board
Well,
than.
let me ask a question slightly differently. Don, am I interrupting you?
Pardon me?
Okay, go ahead. I'm sorry.
Okay, here's my concern.
Well, let me answer my question.
We're in a
Yeah.
period of heavy inflation. What does $25,000 buy these days? How much does a board want to come in here to approve something under $25,000? I think it has to go to at least 50. Personally, I would like it to go to 100. I mean, you and I have agreed in conversation that some of the stuff we're getting is management, not really board issues. For example, if he needs a piece of equipment, it's under $100,000. That's a drop in the bucket in our budget. If we want to limit that in some other way, at another number, we need to have that discussion. But $25,000 is ridiculously low.
Well, there's a subsection of this that whatever number you set, this is a question. There's an emergency authority granted, right? Or is there not? I mean,
Yeah.
so the 25,000 or whatever number it ends up at, right? If is more of a continuing operation kind of an expenditure. But if you ran into a problem where, there's water gushing out of a hole in the wall, you have the authority to solve that, right? I mean, that doesn't require that wouldn't be a $25,000 limit or $50,000 or $100,000 limit, is it? Or
It would probably depend on how big the problem really is. If it's under $25,000 to have a plumber come in and take care of the problem, there's no problem.
no, I'm
with that.
talking something that might, we may have to commit to, something that would exceed the $25,000 or whatever that number ends up.
Windstorm comes through and takes off half the roof.
Yeah,
You
yeah.
got to protect with the building and you got to
Right.
protect the contents. That's more than $25,000.
My question isn't so much about the 25,000. It's whatever that number is, there is still, there is an emergency authorization, correct? I mean, this is more of a procedural question than a specific question.
I don't, well, so I do also want to kind of answer that kind of ties into, I think, what Lane was asking about. Has there been a major problem? So I don't believe there's an emergency provision for me to spend whatever I want
Oh,
without the board.
I thought I
approving it.
saw something about that.
Yes. Emergency purchases may be made without competitive bidding in accordance with section 305.43 A and B of the Ohio Revised Code.
Sure, competitive
So
bidding
that
is,
would have to go back again to Brandon to help us define what an emergency purchase is.
yeah, a competitive bid is different than a board approval. A competitive bid means I don't need to get, if the roof has blown off and I call a roofer and he says I can do it, we hire him to do it. That doesn't mean that if it's over $25,000 that I have the authority to hire that person. So
Oh, wow.
those are two different things.
Yeah.
So
Okay.
if it's over 25, the board still has to take action. So, and to Lane's point, the closest thing that I can think of that we ever had as a court of, it really wasn't even an emergency, but it was a very rapid repair where we didn't go through a procurement process, was when we repaired two of the columns in the wash bay due to corrosion. I think Lane, Chuck, and Donna were here because that was my tenure as CEO where that occurred. That was the only time we used it, but the board still approved that action, but we did not go through a competitive bidding process. So
Because it was less than 25,000.
no, it was about $70,000. So I couldn't do it on my own, but it was, we classified it as an emergency, so we didn't have to go through a bid. But the board still had to take action. I think I don't remember I don't think we had to have a special meeting because there was an engineer involved, but we didn't have time to do the full, 3 to 4 month procurement process.
And that's going to happen.
It can, yeah.
I mean, there's nothing you can do about that. We could predict that. but
Right, yeah, that's what we've been
We're in the
doing.
wrong business.
Yeah.
But isn't there equipment and things that you're bringing to the board still, like floor scrubbers is one that comes to mind? There's gotta be stuff that you could just go ahead and do if you had a higher authorization, that we would not have to deal with something that involves, some cleaning or routine thing in this building.
Yeah, I mean, I think the way to think about it is, what does the board want to review in detail on an individual purchase level? Right? That's really the question. And, the answer to your question is yes, with any gamut of spending authority, with what I currently have, with less, with more. It's really, to me, it's an uncomfortable topic because it's your opinion, not mine, that matters. And it's what you as a board want to individually dive into the details of. Really.
Which goes back to my question. With costs going up $25,000, how often do we want to come in here and for what level of expenditure?
Right, Ben, can you call up that spreadsheet I sent to you?
Yeah, give me a second. I did not.
I went back through the last year just first of the year, last year, looked at all the resolutions. We had 35 resolutions that we passed. Of those 35 resolutions, 1, 2, 3, 4, 5, 6, 7, 8 of them were for expenditures greater than $25,000 and less than $100,000. So, yeah, we had 2 in 23. We've had 2 out of 10, and in 22 we had 6 out of 27 that were there. And hopefully he's been able to call it up as to what they were. But just to run down them, we had the mobile column vehicle lift, we had the utility replacement vehicle, we had a print shop signs, electrical maintenance, utility vehicle replacement, manage IT services, strategic plan. Manage IT services, that would be Cornerstone doing the day-to-day stuff. And then the IT strategic plan and a floor sweeper. Those were the 7 or 8 authorizations. So the reason that I mentioned these are those ones that we feel are critical enough that we need to keep a tighter control over and maintain the 25,000.
I think this is a very valid discussion for the full board. Is $25,000 the right number? Is $100,000 the right number?
Right. And that's the whole purpose
Yeah,
of the discussion
right.
on this whole thing.
Right.
Well, my whole point on the whole thing is you just made it, Chuck. It's not a big deal to have to approve these $25,000 expenditures.
I'm not arguing.
I mean, I don't see any reason to change it. It's been working fine. Nobody's complaining about the fact that $25,000 is holding anything up.
Well, that's why I wanted. to
Why
have
are
a
we
discussion.
fooled? Okay, well,
I just wanted to get people's feelings on this whole thing as to whether or not 25,000 was a too low number or if that was the right number.
well, and the other thing too, that it just points to the fact that we're being good stewards of the taxpayers' money.
Yeah.
I don't think the taxpayers would like to say, oh, sure, Laketran, go ahead, spend $100,000 on anything you want. I don't think they want to hear that. I think this is a good rule right now to prove that we are being fiscally responsible for the taxpayers' money. So why change it? Yeah,
I
That's
think
fine.
there are, again, practical reasons that this should be increased to at least $50,000.
Yeah, if you, that's this listing here,
And what year was that from?
last year and this year,
20.
22 and
And you
23.
can bet every one of those, if we had to do them again, the cost would be higher.
Sorry,
You can bet every one of them, the cost would be higher.
yeah,
There's some you probably didn't,
right.
we could pull out from previous years that are already higher.
I think it's a very valid discussion, one that the full board ought to have.
Yeah.
I would absolutely support having that discussion.
Okay.
Next board meeting?
Just one other point for Lane here. There was a section here, it was paragraph article section 2C that talks about all expenditures of 25,000 or more shall be authorized by the board. And that's great. Expenditures of 2,000 to 2,500 for which monies have been appropriated may be made on authorizations of the general manager and one of the following. And this is where I feel whether we're not following through on all this. So again, authorizations of the general manager and any one of the following: the president, vice president, secretary treasurer, assistant secretary treasurer. He just said that purchase orders and authorizations for expenditures are himself and Lisa. So again, that's not what we're doing today
Well,
at the bylaws.
Isn't she?
but I'm the secretary treasurer.
Yeah, I was gonna say, that's part of the problem with the existing rules and regs. He can approve his own expenditure. I mean, that's the rules right now are filled with inconsistencies like that. And that was one of the major ones that I could see. And Ben, we'll give Ben the opportunity or the authority to spend $100,000 on his signature then. And he can approve it. I don't think that's what we want to do.
Okay, that's fair.
Well, how many transit systems in Ohio have gone to the 100,000 mark or even the 50,000 mark? Does anybody know? Brandon?
I don't remember seeing that in any of the bylaws that I scanned through and shared with us, limited anything like that.
So we may be the only ones that have that in our bylaws?
But again, that's one of the ways that we choose to manage our involvement with the organization. That's what it's boiling down to.
Yeah, this whole argument really boils down to what we're comfortable with as a group. It
Yes.
really, I mean, that's really the issue, right? Is your point, how far in to the process do we feel like we ought to go? And protecting the taxpayers' interests and not hindering operations.
Well, when these bylaws were written around 1974, they $5,000 bought a whole lot more.
Nobody's denying that.
Well, it seems to me we ought to take that into consideration in our conversation. If for no other reason than A, it's highly outdated, and B, these bylaws probably won't get looked at again for another 10, 20 years. How long is this?
Could be.
I think we want to try to lay the groundwork that they are a living document that is going to help future boards address these challenges and not, like 20 years ago, when we attempted to address this, the only thing that got changed was the Laketran was in Painful Township, not Painful. And they left it to us. Do we want to do that again? Leave it for future reference. Let's think about that.
Okay, I think we can probably move on from this one, because again, that's the crux of the issue is where do we want to keep the $25,000 limit, or do we want to raise it or lower it, even if that's the case? Again, there's some other language in that section that I think could use some cleaning up a little bit, but again, the biggest part of it would be what does it take to get, what are we comfortable with as a board to say you can spend without board approval, right? Okay.
I do want to say one thing, which is I think make sure when we say it without board approval, the board still has to approve a budget.
Well, that's
So
true.
there wouldn't be a case when, and this is not to advocate for a change in any direction, but the board still has to in some way approve the money be spent
Right.
at
We are
first.
approving a
So-
budget, but it's got to be within the
Right,
budget.
Right. So there's always one approval process first and then a second for the buying the thing.
Can't go out
So-
and buy.
I just want to make that clear that it wasn't like I could just go write either way, write some giant check without the board approving the appropriation of the funds first.
No CEO can go out and buy. I mean, you know this. Without dealing with your budget, it would be pretty irresponsible.
I do it all the time.
It's so proprietary.
It's a joy of being the owner.
That wasn't helpful.
Well, I couldn't resist, Donna. I'm sorry.
Okay. Move on to Article 7. Yeah. Okay, Brandon, this is going to be for you to talk. I like the idea of indemnification for what it does. I'm not 100% sold that this is the right place to put it, but I don't know where else it could go. So that's why I leave it to you. I know looking through some of those other bylaws, there was only one that had indemnification in it, from what I recall. So again, that's my question, Brandon, is this really the correct place to place the indemnification?
Yeah, and you know, to be quite frank, I have no skin in the game, so it's up to you if you want to be indemnified or not. I think as legal counsel reviewing it, you're looking at ways to protect your board, right? The board says, hey, legal counsel, advise us and tell us how we do these things. I would personally be really uncomfortable without the rules and regulations. The revised code speaks to it. But if I was a board member, and I counsel clients and board members all the time, that you want some protection because your personal insurance might say, sorry. And if you look at the exclusions in your personal insurance policy, homeowners, they're going to likely tell you don't have any coverage or not. And your umbrella policy might do the same thing. So
What do we have right now?
you don't.
Well,
Not at
It's
all.
not
Zero?
by implication through the policy, but the idea is that the board members, think of it as a DNO, like a directors and officers policy, right? For a homeowner association or something. The homeowner association has its own insurance policy, but if it doesn't have specific DNO coverage on there, and Ben can speak to whether or not the OTRIP policy does, but the revised code allows the board to procure its own insurance to protect its own members, right? It doesn't have to be from a public insuring entity. It can be, you could pick State Farm, whoever you want, right? Nationwide does a lot of
It
it.
sounds like we should talk to our insurance person right now, or
the board has DNO coverage through OTRIP.
that's what I thought.
Yeah, you guys are covered.
Yeah.
With OTRIP's full sort of authority limit. So I don't think coverage is a too big of an issue. Now, I'm not, again, no skin in the game on the indemnification language. The only thing I would say is we need to make sure OTRIP is approves of it
Yeah.
because it needs to be consistent with their rules, but you are covered.
Okay, maybe. Does OTRIP? I mean, I seem to remember not only reading, but also from past issue. That OTRIP or any insurer could refuse to cover something. For example, if a board member did something that they deemed was out of bounds from their job as a board member. You're shaking your head. So in that instance, shouldn't we have a backup? Because that doesn't mean that we're not going to still get sued.
Yeah, the easiest thing right here, I mean, my thought is, I propose an indemnification provision. There's probably no sense in belaboring the discussion. What I would do is follow from here to say, let's talk to Barbara Rhodes and Ben and I and see the OTRIP language, see what exclusions are in there, and we can report back on this, because right now we'll probably talk about this and go nowhere. Again, my suggestion initially was, you guys as board members, if I were one of you, I would want a provision in my rules and regulations that stated that. Just so in the event OTRIP or anybody changes their policy, in the event that somehow the DNO provision within the policy or, EPLI, whatever it might be, if that is no longer a part of it, you wouldn't know that. And unless the rules and regulations provide that protection for you individually, take the example, I won't cast aspersions on particular law firms, but let's say somebody gets hurt through the negligence of Laketran. There's nothing preventing the other party and their attorney from suing and naming all of you. Now, a simple motion to dismiss may take care of that, but the idea is who's going to pay for that, who's going to do that, and to the extent that legal counsel on behalf of Laketran can or can't. But again, we go down to all these hypotheticals and all these issues where you may or may not have that ability to be protected. Now, are you defended? Are you indemnified? Maybe, maybe not. So what I would say is this was something I thought was important for all of you, that if I was one of you, I would want it. But I think right now, the most critical element of this is for Ben and Barbara. I probably discuss it and look at the policy. I'm happy to review it. And between the three of us, we can then better provide you with an answer to this.
No matter what they say though, the situation you just described would still exist.
It could exist and still be excluded under the OTRIP policy. And so
Why
that,
would we
well,
not
well,
wanna protect ourselves.
Well, but I have to jump in a little bit on this because there wouldn't, in the case of OTRIP, there wouldn't be a case when you wouldn't know about that coverage because the OTRIP board is made up of the CEOs of the transit systems. And I could never envision a situation where we as a board would approve a risk management policy that allows our boards not to have coverage. So it's not quite the same as a regular insurance company that can change your coverage on you. I would have to approve that change with the other CEOs of the transit systems to take your coverage away. So if I came to a board meeting and said, by the way, I voted to remove your coverage, I think you'd vote to remove me. But I do think that Brandon and Barbara can get language that fits this very easily. And I mean, I think it's a good idea also, but I think you should feel well protected by OTRIP today.
How about and all employees? What does that mean?
I'm not sure what you're asking, but
On your,
Well, the indemnification in here, the way I read it, and I may have interpreted it wrong, but this indemnification was to cover all the employees along with the board. And that's why I put it up.
well, what does that mean? We're gonna cover all employees? I don't get it. What,
Well, I would have assumed that under some of the other insurance policies we already have.
Yeah.
That the employees would have been indemnified. If Laketran gets sued and they're the ones. The driver injured somebody and he's named in the suit. I mean, I wouldn't think we would turn our back on it.
yeah, it's probably, if I put all employees in there, I don't have it in front of me. I'm sorry. That was probably an error.
Oh.
I was specifically speaking of indemnification of the board.
well, I would assume that the employees are already covered.
They are.
Crying out loud.
Yes, the employees are.
Okay.
The idea is and Ben, and again, this is why Ben and Barbara and I need to talk and get a better understanding of what coverage is present specifically enumerated for board members. And again, what I'm suggesting is that in my review of the TARTA and Metro bylaws and some of these others, I saw they had indemnification provisions in there as well, after I suggested that. So it is out there, and ORC 306.35Z provides that you may procure your own policy or policies of insurance for the members of its board of trustees against liability on account of damages or injury to persons or property, blah, blah, blah. So in your official capacity as a member of the board or resulting solely out of the member's membership on the board. So that's why pursuant to 306.35Z, it seemed to me to make sense to include. Yes.
Do we know, or specifically, do you know how many of Ohio's transit systems are indemnified?
I don't, because no one has authorized me, and I haven't specifically said I thought it'd be a good expenditure of legal fees to look at that. I'm happy to do it if you'd like,
Can you
but
find that out?
Every member of OTRIP, so 17 at a minimum. Again, OTRIP was created specifically to cover public transit systems in Ohio.
That's
So
not the question.
that is included in their policy language
How long has it been included in the policy language?
since the OTRIP was created in 94.
Brandon, I have to ask a question. Do we have any ability in the context of this meeting for an executive session?
I would recommend against executive session because I don't know, it'd be best to have that on an agenda ahead of time and specifically enumerate what part of the revised code that allows us to go into executive session would provide for that. I would be hesitant to
Then
do so.
I would suggest at this point, as we did with the last issue, that perhaps we table this to you two talk to Barbara.
Mhm.
And perhaps at that point, we need to entertain an executive session because what I'm hearing, I can only say is not what occurred in the past. And I am strongly in favor of indemnification.
Okay. Yeah, Ben and Barbara and I will talk.
Yeah.
And yeah, that's right.
I mean, I think this makes, again, I try not to have my opinion, but I think this makes perfect sense for the board to have in the bylaws. I just want to make sure that it's consistent with OTRIP's language. So there's not a violate. If we violate the risk management policy, we invalidate coverage for the agency, which
Well, we
would be,
can't,
which would
exactly,
be
we
bad.
can't do that, but sure as heck can add to it, and I personally think we're all crazy to still sit here if we don't have it.
Okay.
And if I could talk to you, Brandon, after the meeting or at some point soon, I will explain to you why.
Just for clarification from my own point, I heard you read the Ohio Revised Code says we can purchase a policy for indemnification. So we have the authority already in the Ohio Revised Code to purchase it. If we wanted to just even simplify this even more, that we just say that the board shall buy a policy for indemnification and then not have to put all this other language in there, I guess is all I'm asking about versus, or even having to put anything in there at all. And I'm just probing here a little bit.
Yeah, and that's a great question. And again, not to punt the ball again, but I'll have a better answer on that after Ben and Barbara, because I'd like to know the language is, because then maybe this is duplicative, maybe it's unnecessary, who knows, but yeah.
At least you know my question.
Sure.
Well, I think it is valid to say, even if it turns out that we are completely satisfied with the indemnification that comes with OTRIP, I think it is probably still appropriate to put some note to that effect in our rules and regulations. It simply says, that we will be indemnified through the OTRIP policy or whatever. Just so it's in the record that there is an indemnification consideration.
Fair enough to me.
Again, I know all of you get paid a substantial sum of money to do what you do. So with that, you probably could indemnify yourselves anyway and provide for a defense, right?
Are you sick?
Well, and it does, the one thing I would say, when if the board does include something in the bylaws that requires them to be indemnified, then you also limit OTRIP's ability to change it in the future, if that was a concern. Because if the bylaws say we must be indemnified, then OTRIP would have to honor that, because by covering us, they would be covering that language also. So it's not a bad thing to put in there, is I guess my point.
Okay, that's not where I thought you were going with your comment.
That's not where I thought he was going.
Well,
I'm glad you clarified in the last few words.
yeah, I mean, it would, if the board said, because the bylaws govern what I do for you, and if the board said we will be indemnified, then that's the message I take to OTRIP as a board member and say, if you're not going to indemnify us, we're leaving. Right. So it does create some accountability, which is why I think without trying to have an opinion on the bylaws in general, I do think it's a good clause to include.
So there'll be some value in having it in there then, in your.
I think so, yes.
Okay.
Okay.
All right. Just to kind of wrap up here just a little bit, Monday at the board meeting, I will make a comment about Article 1, where we talked about it extensively here. And my recommendation is going to probably just be do nothing with it and see if anybody else wants to talk any more about it. I can give them a little bit of what
Article
our
1 is
discussion was
what?
about. Article 1 was the 4 meetings and the board.
Okay.
All right, so we'll see where the rest of the board would go with that. In Article 5, it'll be basically just a single question saying 25,000. There's a lot of things, little things in there that can be corrected, but the big issue is $25,000 still valid as a trigger point for board approval or not, or should be raised, and kind of see where the board goes from there. And then on this Article 7, we'll just kind of say it sounds like it's a good idea. There was some investigation being done on it. Okay. Has anybody got any other questions on any of the other sections? Assuming you have a chance to read some of them. But a lot of it, I think, was just cleaning up language a little bit in different places. And so, okay.
When these issues are all settled.
Yeah.
Is it your intent to circulate a copy? Brandon, I'm kind of addressing you here too. Don't mean to interrupt your typing, but are you guys going to circulate a copy for like another look-see before we're expected to vote on it?
Oh, most certainly, most certainly. We wouldn't just throw something at you and say, here, vote on it. I mean. we'll give
I
you time.
just wanted to clarify.
That's fine, yeah. The spreadsheet that Ben had up on the screen there, would there be value in handing that out Monday? To the
With,
board?
with
Which
the
spreadsheet?
expenditures,
Yeah,
as part of the discussion, sure.
okay. So we'll have copies then available to hand out on Monday.
Heard that as a, you will have copies available on.
Well, I can make them, I can make them,
Whatever you want.
but I'll ask you to do it then. if you
Okay.
Wouldn't please, or Miss Trudy.
Nope, I will, we will have copies. for the board.
Was this of any value to you, Gary, to see this?
Yeah.
Okay.
I'm kind of neutral on it, but it may be important to other people to see.
Okay,
I think it's valid, but only to a point because of the way costs are going up.
yeah.
That could look entirely different looking back on this year.
Well, an example that I throw out on this a lot of times is the utility vehicle that we just approved last year, or just even most recently, for 37,000. Yeah, 37,500. I mean, was that something that we really needed to give approval on, or could he have just gone out and bought it? That would be that's kind of where the question is on some of it.
And that's a valid discussion. I
Yeah.
think that's a valid, we ought to get the temperature of the whole board, absolutely.
Are there other examples like that, Chuck? Things?
Well,
we
there
have-
was 8 of them. There was 8 of them.
You have the utility vehicle? Yes.
I'm not trying to
okay.
belabor this discussion here either.
You're killing each other.
Are there any? He asked about whether or not this should go to the board. We're in general agreement. My question is, if we're going to discuss this fully, should there be a list of 100,000 down to show what they were?
I can give you the other sheets that came with it. Those were just the ones that were between 25 and 100,000.
Okay,
Here's the 35 resolutions that were passed. We can provide copies of this too.
yeah, could we have a copy of that?
These are for you. I got it electronically. I'll make copies.
This is all one document, right?
Yes. That's the document.
We have them the whole.
Yeah, it's all one document.
A little more instructive about what we potentially be responsible for rather than this eight.
Have at it. We'll have a discussion.
Hey,
Okay. Is there any other discussion about this topic that would like to occur? Hearing none, then I will call for adjournment. Trudy, could you call the roll?
McNamee,
yes.
Sheets,
Yes.
Swanson,
Yes.
Zibble.
Yes, I understand. I thought you said last time we had to do the roll. You could do that.
Simply saying we could do that by affirmation in a special meeting with a limited number, but the roll call is fine too.
Okay. That's what I was just telling him.
It's the same number. It's kind of easy either way.